The first message is, yes, those of you who are new to this process may be amazed by its complexity, but it's actually quite simple. After where we are now, we can see that the whole process is irreversible. That is, the result will come, and I think the landing platform is increasingly clear. It will be in the course of 2015. Why is this so? Well, to some extent, it's based on positions which have already been made public. And as just said, the Parliament is 50% of it, and they may have dealt with 4,000 amendments, but the outcome is also a position which is not a final position, but a position was adopted with a landslide, a huge landslide, 600 to 10 or something of this kind. And that means that the new Parliament is very, very likely to follow up on its previous position. It is very unlikely that this will change. The central political parties will be backing it, but there is also the institutional tradition. The Parliament wants to be taken serious, and it's not going to go back from the main points. It will negotiate, but it is not going to go back on its main points. The second is the Council is also, in spite of the principle nothing has been agreed until everything is agreed, the consensus, the degree of consensus is increasing. And we've now reached a point where the sense of urgency is very clear. And it's between the lines and also in messages you may have read last week, the European Council, which the heads of state, heads of government sending strategic signals. The signal is this should now be delivered by 2015. And a very important, that's flexible language, of course, but it coincides with all the signals we see coming. And an important role in this plays the Court of Justice. It's deciding on cases. It certainly does not decide on the data protection review. But it is increasingly sending the message that the data protection as a fundamental right, the Charter of Fundamental Rights, is having an impact. And in fact, it is cutting out lines which turn out to be red lines for the review itself. So, as an example, it has spoken 3 times about what an independent authority should be. That's a line the legislator can no longer cross. In the Google case, it has referred to the rights of erasure and objection, with 3-4 times referencing to the Charter of Fundamental Rights, the elements of those rights being spelled out. Not in detail, but they have been sort of by this reference to the Charter become part of the debate. And maybe a red line is overstated, but there are red lines shining through the debate. So I think the outcome and the process is irreversible. And I would, at this stage, safely predict that there are some 5 to 6 points which you can now see coming in substance. The most easy is, of course, where the Council has agreed on a partial general approach, which is without prejudice to possible changes and so forth and so on. But the truth is, we now know for sure that the scope of the framework will be wider than the present one. It will be wider even than the court found in the case Google Spain. And in fact, that outcome precedes the idea that being active on the market as such triggers scope of European law. And we know fairly that, for sure, that the chapter on transfers will stay more or less as it is now. Some details, but we'll come to that perhaps also in the afternoon. More on substance, I think we can fairly predict now that the rights of the data subjects will be stronger. They will be stronger because they've been provided in a single framework, but also a number of reinforcements all in different levels. Emphasis on erasure, possibly some collective actions, some burdens of proof which have shifted and make the position for the data subject on the whole much stronger than they presently are. There will also be a reinforcement of the obligations of controllers. And I'll come to some of the big issues at the end. So that's a stronger position in terms of responsibility not being a definitional notion or something at the end, but something which requires engagement from the beginning. So you need to be active to act as a responsible controller, take measures, demonstrate, etc. That has not been challenged by anybody, certainly not by wide majorities. And the Parliament is very keen on delivering this as well. Stronger positions of data protection authorities. The message on fines is crystal clear. We cannot predict the maximum fines, but the direction is clear.